Hi and welcome to this latest immigration law conversation video. In these videos, I discuss with experts current issues of immigration law and practice. These are informal discussions, they're not legal advice, but they're meant to inform and help practitioners and others. And today I've got the great privilege of being joined by Chris Cole. Chris is the head of immigration at Parker Rhodes Hickmotts and is a very experienced immigration lawyer and part-time immigration judge. So today I wanted to have a discussion about digital appeals because, well, that was the way that the tribunal were moving with the reform pilot. And now since coronavirus, there has been a move to digital appeals within the first tier tribunal. And since the 22nd of June this year, the majority of appeals having to be started by the digital process. So Chris, thank you so much for joining us today. Perhaps you could tell us first a bit about you and what you do.
Of course. Well, thank you very much for inviting me, Adam. It's a pleasure to join you in this conversation. As you say, I'm an immigration solicitor, been a solicitor for over 20 years now, been a partner at Parker Rhodes Hickmotts for a number of years. We have a team of around 10 of us dealing with immigration matters. We do the whole range of immigration work, but mine caseload is mainly sort of asylum appeals and human rights appeals. I concentrate more on the complex issues. And as you mentioned, I also sit as a part-time immigration judge in Manchester as well, and have done for about 18 months now.
When I thought about doing a video on digital appeals, you were the first person who came to mind, Chris. You've become a bit of an expert on digital appeals. Just tell us what your involvement has been in the whole digitalization process.
I do seem to have been involved for a long time now. I also sit on the Law Society's Immigration Law Committee, and HMCTS and the MOJ have consulted with the Law Society and other rep bodies about the new reform and digital process. So I think I first had meetings regarding this possibly at least sort of more than 2 years ago. And then I was privileged to have HMCTS come to my office to demonstrate the early versions of the platform and so on. So that involved at a very early stage, which was interesting. The first pilots were in Taylor House in London and Manchester. So my initial involvement there wasn't as a rep, but as a judge. I sat in a number of reform appeals. Interestingly, one of the first fee-paid judges to be allowed to do it. I think that I was seen as someone with technical ability, whereas some of my colleagues, judicial colleagues, weren't quite as sort of adept at dealing with the tech. So I dealt with some, as I say, as a judge. And then Bradford, which is my local hearing centre, came online in September last year. And so we embraced the reform process and started lodging all our appeals as soon as possible online. And so we've been through the process, and I've been an advocate as well in Bradford in a number of reform appeals. So I've seen it from a number of different perspectives, which I think is useful to see.
And in terms, putting your sort of practitioner hat on, what do you see as the benefits of digital appeals, both in terms as immigration lawyers and perhaps the potential benefit for clients going through the digital appeal process?
I think there are a number of benefits for practitioners. I think having one platform where all of the documents, directions, everything is in one place makes life a lot easier. And it's a simple platform to use. Lodging an appeal takes possibly 2 minutes max now. It's filling in the client's details, tick boxes about what are your statutory grounds of appeal, and if you are the basic details, and that's it. It takes no time at all. So that's very helpful. Personally, I like the lack of paper. In our immigration department here, we've tried to reduce paper use for a long time, and so this is really helpful. When you're uploading a bundle, you just upload a PDF, whereas previously we would have to print out hundreds of pages, send them to the Home Office, send them to the tribunal, and then if you're instructing counsel, sometimes you'd have to send, so you 3 copies of the bundles, a huge amount of paper, huge amount of cost. So making that more efficient is really helpful. I think I've always preferred working digitally personally. Sometimes I like a piece of paper. It's nice. I have some in front of me now, but working on a screen to me comes naturally. So that, if you're used to it, I think it's good. And I say the savings in postage and paper are fantastic. I think the way that the tribunal caseworkers who deal with most of the sort of issues during the processing of the appeal and up until the hearing is much easier. Now you have someone that you can email and get in touch with and get responses with, whereas certainly my experience, when you were applying for adjournments or additional time previously, often it would just be ignored, or you wouldn't get it, or you would be refused on the papers and you'd end up traipsing to court and the judge on the day granting it. So being able to deal with things electronically in that way, I find really helpful as well. And getting to a case and having a hearing when everything's ready, it makes the process longer, which for clients can be a bit troubling, because it does take a fair amount longer to get to the hearing. But, and this is the whole sort of rationale behind this, is that cases will only be listed when everything's ready. Everything is being checked, and the chances of having an adjournment on the day are very slim, because everything's been checked before, everyone has, all the documents have been submitted, and so on and so forth. So it does alleviate those sort of wasted journeys to court for appeals that get adjourned at the last minute because something comes in late, or the Home Office raised something late, or you knew you wanted an adjournment in the first place but it was refused on the paper. So there are benefits. I think also the idea of the Home Office actively reviewing the case before the hearing has got to be a benefit for all sides, as long as the Home Office properly engage in that review process, weeding out those, which we all have, we all experience those cases where we think, how did the Home Office reach this decision? This is just perverse. And so if there's a proper review and those cases don't get to a hearing, that's got to benefit all parties, particularly the appellant, any client, the case gets resolved earlier. So there are some positives about the process.
And just a couple of follow-ups in relation to that. How have you found the Home Office engagement in the cases you've been involved in, on either side of the fence, when sitting or as an advocate, in terms of actively reviewing and narrowing down the issues?
I would love to say that it's been consistently good, but it hasn't. Interestingly, my experience of having seen the reviews from the Home Office in Manchester, they do seem to be engaging more, whereas the reviews that I've seen from Leeds as a practitioner on my cases sometimes don't appear to have actually been what I think is the intention. It seems to be a lot of them are just relying on the refusal letter and saying, yeah, well, these points put in the by the appellant don't really take matters further, we still rely on this. I think we've lodged around 60 appeals, and probably at least half of those have been through the review process. Thus far, we've only had 3 that have been reviewed and overturned. And 2 of those were linked appeals where the only issue was whether they were a refugee convention reason. So it really was straightforward, because the Home Office didn't realise that a family member could be a particular social group. They'd never heard of K and fauna, which is a bit of a worry. But so that would, those 2 were such a sort of narrow issue. So on a more general basis, we've only had 1 reviewed and overturned, which I think is a bit disappointing. And in terms of narrowing issues, again, very few. I had a Turkish-Kurdish case where I thought, well, they didn't accept he was Kurdish, but with the extra evidence, at least concede that issue. It's not going to make or break the case, but no, they still insisted on relying on everything. And you may know that Iraq is my sort of area of expertise, because I've done, it seems, nearly all the country guidance cases over the last 10 years. But I had an Iraqi case where the Home Office in their review even managed to expand the issues, because to me the only issue was internal relocation to the IKR, the Iraqi Kurdish region, and it wasn't Baghdad, and I didn't think the refusal letter even mentioned Baghdad, but the review came back and said, well, no, it's internal relocation to Baghdad as well. And I went back via the TCW to say, are they sure? Because that's not what the refusal letter says. And then admittedly, the TCW got the Home Office to respond, which was helpful. But no, they said, no, that's what the refusal letter says. Obviously, it was a pointless issue for the Home Office, because my client was a Kurd from somewhere else, so that no judge, very few judges, would find internal relocation to Baghdad reasonable. But it just shows that sometimes I don't think the Home Office are engaging as much as they ought to be with the review process, which is a bit disappointing.
No, absolutely, and it's been a bit hit and miss, definitely. I think it, as you said, depends very much who's conducting the review. One thing I've that's come out of a couple of your answers already is this relationship between representative and the TCW, and perhaps using the tribunal caseworker in order to, like you said, respond to the Home Office on those issues, not to list a case before it's ready, to sort out issues, and that sort of closer working relationship than we've historically had. Just one other follow-up question before we move on. You said you liked, as an advocate, working digitally. I love digital things, but still, as a barrister, I quite like a paper bundle. I don't know if it's a security blanket for me. How have you found, as an advocate, presenting cases just on a screen effectively, and be able to navigate, say, on an Iraqi case where you have quite a lot of, say, country information you may need to refer a judge to?
It's more difficult, and it's something that you need to get used to. The way it works at the hearing is that it's the judge that controls the main bundle and the screen. So as an advocate, if you want to refer to something, really, the judge then has to find it, which, again, depending on your judge, can be a bit frustrating. So that's slightly awkward, but because the way that the reform system works is that there is a hearing bundle produced by the tribunal caseworkers, which is everything consolidated into one bundle. So it includes your appeal skeleton argument, the respondent's review, the Home Office bundle, the appellant's bundle. So they can be a huge PDF, and it's quite difficult to manage. I think it's very useful to have good quality PDF software. We use a version of Adobe Acrobat Pro DC, I think it's called, but obviously others are available. But to help be able to, and to know how to highlight and to bookmark, so that you can then refer the judge very quickly to the page number of the hearing bundle, so that then they can find it on the screen that's their screen, and the screen that's showing to the appellant. Because I say it's a very different process. Simple things like getting your client to adopt their witness statement. Usually, I have a piece of paper and I say, do you remember this? Is this your signature at the end? But of course, no. You have to refer to the judge to find it in the bundle, who then puts it on the screen for the appellant. So initially, it can be slightly awkward. But personally, I say once you're used to it and it becomes the norm, I like it a lot. I have my laptop, then there's the screen that the tribunal have that you're sharing with everyone, and I find it quite easy to navigate. But I say it is something you need to get used to and start practicing with.
And on your laptop, do you have a separate copy of the bundle, or are you just taking notes on your laptop and relying on the judge's, the laptop that's controlled by the judge?
It depends. I take my notes on my laptop, but I would also have in the background my copy of the bundle if I needed to. And there's me being this sort of going on about not using paper. I have to admit, occasionally taking a paper copy of the bundle as well, just while I'm getting used to it, just as a backup in case anything goes pear-shaped. But certainly when I'm sitting as a judge, I just have, there isn't a paper copy produced, and I think I would get frowned upon if I was asked someone to produce it. But as the judge, you have 3 screens, which makes life a lot easier. Because I have my laptop just for taking the record of proceedings, and then one screen that I'm controlling, that everyone looks at, and then another one just for me, for anything that I want to look at before I bring it to everyone. So I think everyone's found this during lockdown, that multiple screens are the way to go.
Yeah, absolutely. I think some of the takeaway advice, perhaps for practitioners, would be to make sure they invest in the appropriate license for a PDF software, and make sure their staff. I had this conversation with a solicitor this week in the context of creating a judicial review bundle that needed to be sort of hyperlinked and fully using a PDF software. So make sure your caseworkers are familiar with using this kind of software to be able to hyperlink, highlight, and create a digital bundle. What are some things practitioners need to look out for, some sort of potential pitfalls, just things to be aware of that could trip them up in this process?
As I say, the myHMCTS platform for lodging appeals is pretty straightforward and fairly simple. It is still a work in progress. That's what I think people need to be aware of. And if there are glitches, it's really important to email the tech team, because there are some little quirks about it that I find really frustrating from a supervisor's point of view. When you set up your account on myHMCTS, I assumed that as sort of the super user, the administrator, that I would then have access to any appeal lodged on the system, but apparently you don't. It's only the individual caseworker that lodges the appeal with their own login that then can see the notifications and the documents, which obviously from supervision, or if someone's on holiday, makes it impossible. So there are sort of 2 solutions to this. There is the option to share every case with a colleague, which is what we do now. Everyone shares, all of my caseworkers will share their case with me, so that I still get the notifications. But I know other firms, what they have is they've set up a sort of a generic email and a generic login, so that everyone uses sort of their immigration appeals at my solicitors, whatever it is, email address. So it has one sort of generic login and a generic email address where everything goes to, which is another solution. But it surprised me during lockdown, when I had lots of my staff were furloughed. We had the tribunal saying, well, what's happening with this appeal? And I was looking and said, well, we can't see it. I've got this whole list of appeals, but I can't see it. And that's when I discovered this. So there was no warning. So there are little sort of quirks that you find that I don't think HMCTS have realised as yet. And it's not fully integrated yet. You still have to email directly the TCW rather than going through the platform. As yet, you can't pay tribunal fees via the platform. As far as I can tell, HMCTS sort of guess if it looks like an appeal that needs a fee, and then they email you about it, and you pay it sort of the old-fashioned way. Although all of these things will be integrated, so it is still a work in progress.
And just in relation to that, if you were instructing, say, me as counsel to represent on one of your digital appeals, do you give me access to that case on HM? How does that bit work, say, in instructing counsel?
I suppose in theory, if counsel had their own myHMCTS account, we could add them as a user and then share that individual case with them. At the moment, because my firm, we tend to only involve counsel for the hearing stage. We draft our own appeal schedule and arguments and so on. So we would just send them the hearing bundle. But if you wanted to involve counsel earlier on, I see no reason why they couldn't be. They would have to. I think you'd have to add them as a user to your firm's myHMCTS account, and then share the individual appeal with them. Which I don't think. I can't see any reason why that couldn't be feasible.
Yeah, I think probably the way you do it now in just sending the bundle would be easy. And even if we drafted the appeal skeleton argument, we'd probably forward it to Solicitor for them then to upload and deal with on the platform.
Yeah, I think most solicitors would want to have control of the sort of the submission and so on and so forth. So I can see it's possible, but I say it's not the way that we would work as yet.
And we just mentioned the appeal skeleton argument. That's sort of become a far more important document. It's been quite a controversial document and issues around legal aid. Just perhaps tell us how that's different from a traditional skeleton argument and what role it plays. Perhaps I always thought the name appeal skeleton argument was a bit of a misnomer, and perhaps it should have been written summary or submissions or something like that. So yeah, what are your reflections on the appeal skeleton argument?
I think it has become a real sort of contentious issue, and the tribunal have caused all sorts of problems by describing it in very different ways at very different times all over the place, and there hasn't been any consistency. I suppose we have to just look at the latest presidential statement to see this is really what it means. Personally, I don't think it's that different from any other skeleton argument. It's quite prescriptive about how you should set it out, but I actually quite like it. You have your factual summary, then your schedule of issues, and then your submissions in relation to those issues. And it's important just to be able to explain why the Home Office decision is wrong. And it's dealing with the different points in the refusal letter. I think it's good that it says you shouldn't put reams and reams of cut and paste from case law. It's the principle that matters. And I have to say, I had this sort of issue, the case I mentioned earlier about particular social group. Initially, I put in huge reams of bits of K and fauna. And I thought, well, no, we all know what it says. And K and fauna was in, the whole case was in my bundle. So there's no point in me repeating it. So all I did was, highlight the principles. So my appeal skeleton argument was only, I think 2.5 pages, because it was a simple issue. But obviously, if you've got a more complex case or one that's got lots about credibility, they've got to be longer. But it's focusing on the key issues about why the decision is wrong, so that the Home Office can then undertake a meaningful review. I don't think it should be a sort of a scary or daunting document, but it is important and it's got to be done right. You've got to sort of think carefully about what the Home Office is saying and then address each point as succinctly as you can. Say, this is what they're saying and this is why it's wrong, and it's because of this legal principle or because of this part of the evidence, and cross-reference to your bundle. I always make sure that I've done my bundle first so that the appeal skeleton argument doesn't repeat what's in the bundle, but cross-references to it.
No, that's really helpful, because if a caseworker who's then reviewing the case, or a presenting officer reviewing it, can see by cross-referencing that something wrong, or that, say, a legal principle like the fauna principle hasn't been applied, hopefully then that will lead to concessions on those issues and again narrow the focus of the appeal. We've talked a bit, Chris, throughout our conversation about the myHMCTS platform. I was having a look this morning and I can see they've put on guidance documents for the different stages of immigration and asylum appeals. But what would you say in terms of to practitioners about the whole thing about signing up, and just some tips in relation to myHMCTS?
Well, as you mentioned that date of the 22nd of June earlier, I would like to think that everyone is now signed up to myHMCTS, because basically nearly every appeal has got to be lodged through that platform. It'll be the exception rather than the rule, those that are lodged by paper. And it is a straightforward process to go through, but it is essential that the right person is the administrator that logs onto it, because they then have the power to add users. And you have to make sure that how you're going to do it, whether you're going to have a generic email address or whether you're going to give it to the power to each user. But as I say, I would like to think that everyone who needs to use it is already signed up. And even if for some reason you haven't had an appeal, because obviously the Home Office haven't been making a huge number of decisions during lockdown, although we seem to have been having quite a lot over the last few weeks. go on to the myHMCTS website, as you say, read the guidance and get yourself an account even before you have any appeals to lodge. So at least you can work out how it works, have a little play with it, look around. And I think there is some pretty good guidance. And if you have any problems, I know each of the hearing centres has presented some sort of training. I saw some slides from, I think it was Glasgow, hearing centre came out in May. So I'm sure if you contacted a TCW at any of the hearing centres, they would send you their training slides, because as I say, each hearing centre has had that sort of training for practitioners.
No, that's really helpful. And what I'll do, we've referred to the Presidential Practice Statement number 2 in our conversation. I'll put the link to that below the video. I'll also put the link to myHMCTS, where you'll be able to see the guidance in signing up, and also where the various guidance documents are in relation to immigration and asylum appeals. Chris, it's been so good to talk to you, and I think that gives us all sort of a helpful steer in where appeals are going, because we certainly, even when pandemic ends and social distancing ends, I think the digitalization is not going to stop, and clearly this is somewhere which practitioners need to get familiar with. There will be cases that may not be suitable for digital appeals, we all accept that, but obviously this is the direction of travel, and practitioners need to get themselves fully equipped for that. If people want to contact you or the team at Parker Rhodes Hickmotts, what's the best way to do that?
There are two ways. Either they can just email us at info@prhsolicitors.co.uk, but I'm more than happy for people to contact me directly about issues regarding to reform appeals. I may be opening the floodgates, but yes, as I say, I'm really happy to give people tips, and if they're having issues, not a problem at all. And my email address is chriscole@prhsolicitors.co.uk.
Chris, that's really helpful. Thank you so much. I hope that doesn't mean your inbox gets swamped with inquiries about digital appeals. Normally at the end of interviews, I say to people, I look forward to seeing you in person soon, but I suppose I should say to you, I look forward to appearing in front of you in a digital appeal soon, because that would be fun. Although you might see me carrying a sneaky paper bundle just as a security bank. Yeah, Chris, thank you so much for your time today.
Well, thank you for having me, Adam. It's been great fun.
No, that's great.